So with that, I'm going to pass the torch to the next speaker.
Hi, everyone. So I was originally going to do criminal developments for Prop 64, but I think we should kind of shake it up a little because we've heard a lot about marijuana regulations. So I kind of want to talk to you, I guess, a little about my experience kind of in the trenches of the war against marijuana, which we're just coming out of, actually, surprisingly, in the courts, and what you need to look out for as a practitioner, considering that it's still a violation of federal law to be involved with marijuana activities. So you heard a little bit about the beginnings of marijuana law in California. It started in 1996 with the Compassionate Use Act. And in the beginning, we basically had laws that immunized certain types of conduct from criminal sanctions. In the beginning, there was an initiative that said you can grow your own marijuana or you can grow as a caregiver for others. But that was a very limited concept, which means like you could grow marijuana for someone who had an extreme medical condition where you had to actually do caregiving for that person. And that kind of prohibited the idea of these mainstream dispensary type stores that's more convenient, obviously. So because there was a need for dispensaries, the legislature actually passed the first marijuana sales legislation, not just recently, but in 2004. And that was also this kind of immunity type of clause. And it basically said certain conduct, again, was immunized, including marijuana sales, marijuana transportation, any other kind of marijuana conduct would be immunized if qualified patients collectively associated to cultivate marijuana. Now, it also had this other clause in the law that says this must be done on a non-for-profit basis. Now, you've heard that this kind of requires a nonprofit. Well, that's actually not really true. When you litigate these criminal cases, but I'm going to tell you two kinds of advice. One is like a criminal defense advice, and then one is like a proactive advice when you're dealing with people who are trying to comply. But as a criminal defense attorney, the law until January 1st, 2019 is still that patients who collectively associate, as long as they're doing it on a non-for-profit basis, may have immunities. And what does that mean in practice? Well, I mean, it can mean like you have a client, this is like an example of a case I actually went to trial on and we ultimately won. A guy with a bunch of weed on his body and in his car, there's a search warrant executed. He has text messages to friends that have, some of whom have recommendations, saying like, you know, can I get a bud? Can I get an eighth? Okay, so that kind of scenario, you would think like, how do you have a defense? But actually what's awesome is because of the way that the medical marijuana law was written, and this is Health and Safety Code 11362.775, it's still there, is very vague. Even though the AG guidelines say you have to have a corporation, when you look at the CalCrim, which is the jury instructions for this that we finally got in 2015, it says that it has to be non-for-profit. When you have like a few people you're selling to, that doesn't mean you necessarily have to have a non-for-profit corporation. What it means is that you have to somehow frame your activity into marijuana sales that result in a person who's the operator having a salary that's based on overhead costs and operating expenses. But on a criminal level, it's been really fabulous. We've been able to basically get people off of felonies until Prop 64 for many years based on the vagueness of the law. Now, what's strange is that the reason that the law was weird and vague and only immunized conduct is because we have this federal law called the Controlled Substances Act that says that regulating marijuana is actually illegal. Okay, this is very strange because now we know in the context of the country we have many states that are now regulating marijuana. Well, although that is the law of the land, the Obama administration put out this memo that was discussed that said that basically if people have robust legalization systems, then the feds will generally stay away. So this is very strange as a lawyer because, you know, first of all, a violation of federal law makes it less likely you're going to be prosecuted. That's very odd. But that is what that was what the Cole memo said. Now, did that memo prevent the DEA from further doing anything? Not really. And did it prevent U.S. attorneys from prosecuting people? No. But for the last 2 years, we've had this thing called the Rohrabacher Farr Amendment in Congress that says that the DEA can't use funds to medical marijuana states. Now, does that stop the DEA? Well, what we have to understand is that this is like bureaucratic politics. It's way beyond what's the right thing to do. Should marijuana be legalized? We've had since 1968 huge bureaucracy and law enforcement that's been set up to deal with marijuana offenses, other drug offenses. Half the federal prisons are still drug offenses. So even though we have this memo and we have this amendment, the DEA and U.S. attorneys can still file cases. You guys heard a little bit about the U.S. versus McIntosh case, and that is a good case from the Ninth Circuit that says if you're in strict compliance with California law, you have the right to an evidentiary hearing in federal court. Now that sounds awesome. Of course, no one ever has successfully had this evidentiary hearing yet, so it sounds great. But the reality is, and I don't want to be like scaring people because there's been very few federal prosecutions over the last few years. However, the reality is that you'd be, or your client could be in a position where they're fighting a federal case that's 10 years to life, which is usually what federal cases are. And okay, so they have a medical marijuana defense possibly, which we don't even know what that would mean. And what it says in the federal court is that strict compliance is what you have a defense for. But then we're going to get into the issues. I'm kind of going to discuss like what are the issues in the future. Well, what does it mean to be strictly complying? Well, the district attorneys in California from 2004 through even like currently, they think you can't even sell marijuana in California. Their position is that all sales are illegal. And the federal government has also taken that DA position when they're litigating these post-McIntosh cases. They're saying, well, you will have to, they're taking the positions that the DAs took for many years litigating these cases that there really aren't sales allowed, that you have to be a caregiver. So when we think about, yeah, there's a federal defense, but when you get into federal court and you have US attorneys arguing whether you have a defense, they're gonna take a very narrow view of things. So it's in that context that we now have these massive changes in criminal law relating to marijuana and this regulatory system. And the basic changes in criminal law from Prop 64 has been that all marijuana offenses in the state are now misdemeanors, unless the marijuana is being distributed out of state, and or the person has a super strike, which is like a murder or arson, something very serious case, or they have a 290 sex registration. And if you have any of those categories, then it's still a wobbler, meaning a felony or a misdemeanor. But this is obviously great news for like the random marijuana grower or transporter. That is doing it even, in this weird gray zone that many of the speakers have already talked about, that now it's a misdemeanor offense versus a felony. Another great change that's happened is that the smell of marijuana is no longer probable cause. So that's part of Prop 64. That started November 8th of 2016. And that, it's very exciting. And that's, I think, a way that I think the government will, not have a chance to get into as many people's lives. So the state basically has, in large part decriminalized marijuana. That's a great thing. But because there still is this federal bureaucracy and the DEA out there, that actually, if this appropriations rider doesn't get continued, then any activity that we do now can be enforceable if it's within the statute of limitations. So that's just also something to note about McIntosh. That let's say that next week they don't continue the appropriations rider, then any conduct that we do, like even within the statute of limitations, can be prosecuted when there's no rider. So it's just something to be very aware of when you're, dealing with marijuana cases. I would say that whenever you have a conversation with a potential new client, you should treat them as if they're basically a DEA agent. I mean, I know a lot of people might think I'm paranoid, but that's the way you should handle it. So I'm happy to take any questions afterward, and we'll hear from one of my opponents.